Close your eyes and begin to relax. In our system, a lawsuit commences with a document we shall call the complaint. What exactly should this complaint do or say? Should it provide all of the factual information that the plaintiff knows about the case, or just a sketch? Should it contain the legal authorities on which the plaintiff intends to reply? Should it include anything else? Must some magic formula or legal incantation be invoked? To whom should the complaint be given, and how? What, if anything, can or must the defendant say by way of answering the complaint? Are the parties wedded to what they have said, or can they change their initial statements? Can they be punished for saying things that turn out to not be true? The system of pleading provides answers to these questions. But these answers do not exist in isolation. Understanding the rules of pleading requires an appreciation of the purposes. Section A. Perspectives on pleading. The American legal system separates the pre-trial stage of civil litigation from the trial stage. A major function of the pre-trial stage is to ready the case for trial. Basic notions of fairness, as well as the need to have a well-run trial, demand at a minimum that each party notify the court and other parties about the general nature of the legal and factual claims that the party will assert at trial. Although this point is more debatable, fairness and efficiency may also be better served if the pretrial process allows the parties to explore the legal and factual contentions in the case, and to narrow down the contentions to those in serious enough dispute that the machinery of trial must resolve them. Given the finiteness of time, money, and human knowledge, no pretrial system can perfectly perform the tasks of notice, factual development, and issue narrowing. But a good pretrial system should attempt to accomplish and will ultimately be judged by its success in accomplishing these functions. The pleadings, which are formal written exchanges that set out the parties' claims and defenses, are the first step in the pretrial process. If the pleadings are also the only step in the pretrial process, then the pleading system bears the entire burden of accomplishing the pretrial functions. If other pretrial processes follow the pleadings, then the pleadings need to accomplish less. How much less depends on what the remainder of the pretrial process does. Against this background, we can begin to evaluate the modern American pleading regime. The following readings describe the philosophy underlying the federal rules of civil procedure, as well as the philosophies underlying the common law and code pleading regimes that the federal rules replaced. Charles E. Clark, Handbook of the Law of Code Pleading. The pleadings serve the primary purpose of acquainting the court and the parties with the facts in dispute. In so doing, they should point out that actual issues to be settled. Several other purposes may also be served by the pleadings: to serve as a formal basis for the judgment to be entered, to separate issues of fact from questions of law, to give the litigants the advantage of the plea of res judica if again molested, to notify the parties of the claims, defenses, and cross-demands of their adversaries. The purpose, especially emphasized, has varied from time to time. Thus, in common law pleading, a special emphasis was placed upon the issue formulating function of pleadings. Under the earlier code, pleading-like emphasis was placed upon stating the material, ultimate facts in pleadings, while at the present time, the emphasis seems to have shifted to the noticed function of pleading. We gradually learn to expect less of pleading. The insistence on it seems not worth the price. It takes great skill as well as a thorough knowledge to be a good pleader. Many judges naturally hesitate to sacrifice the rights of clients because of pleading mistakes of their attorneys. We still expect something of pleading, but are more disposed to realize that there are difficulties in the way of complete achievements of its ends. Nearly all now recognize that the old expectation of narrowing the issues, that is, forcing an opponent to cut down his claim or defense only to the size one wishes, is by and large destined to no other success than to delay the case and waste the time of the courts. Notice pleading differs in the main in the extent of generality of the statement permitted. Thus, instead of describing the particulars of an accident, only the time and date of the accident are referred to. There is not so much a change in the kind of pleading as a change in emphasis. The common law pleading both set forth facts and gave notice, but stressed mainly the framing of the issue. The code produced one or more issues and gave some notice, but did this while setting forth the facts. So notice pleading giving some facts presents a very broad issue. The code purpose of stating the facts did not work. This was the least successful part of the code reform. It may therefore properly give place to the purpose of fair notice. Christopher M. Fairman, Heightened Pleading. The architect of the federal rules, Charles E. Clark, and his fellow drafters created an entirely different procedural vision for pleadings. They wanted something simple, uniform, and transubstantive. Historically, pleadings have served four key functions. 1. Providing notice of a claim or defense. 2. Stating facts. 3. Narrowing issues to be litigated. And 4. Allowing for quick disposition of sham claims and defenses. Pleading, both at common law and under the codes, shouldered all four of these responsibilities. Instead of requiring pleadings to serve the multiple functions of notice, fact development, winnowing, and early disposition, under the federal rules, pleadings serve but a single function, providing notice. In turn, the federal rules provide alternative techniques that are better suited to fulfilling the non-notice functions. Fact development is achieved through discovery. Issues are narrowed through discovery or partial summary judgment. Quick elimination of sham claims and defenses is achieved with summary judgment. Rule 8 operates as a keystone to an entire procedural system where the only function left to be provided by pleadings alone is notice. The notice function of pleading, however, cannot be divorced from the global vision of the drafters. Litigants should have their day in court. Consequently, the rules were designed to encourage determination on the merits. Rule 1 embodies this with its command for just, speedy, and expensive determination of every action. The break with common law and code pleading is but an illustration. These earlier pleading regimes denied litigants their day in court not because their claims lacked merit, but because of procedural technicalities. The federal rules remove these procedural booby traps. Thus, notice pleading and the rules as a whole establish merits notice pleading and the rules as a whole establish merits determination as a new procedural norm. Despite the seeming clarity regarding pleading requirements under the federal rules, judiciously imposed heightened pleading requirements blossomed in many areas. Chief among these is the civil rights context. Federal courts began to impose a heightened pleading requirement in 1983 cases during the 1960s, fueled by concerns over burgeoning dockets and a perception of recurring frivolousness. Congress has recently embraced heightened pleading as well. Rather than target the federal rules for reform, Congress created special pleading rules for specific federal statutory causes of action. Courts and the Congress continue to turn to the procedural device. Whatever their legitimate concerns for protection of defendants may be, heightened pleading is a poor procedural solution. As both the civil rights and the PSLRA experiences document, heightened pleading is unworkable because of inherent inability to articulate the applicable standard. These plaintiffs are compelled to do the opposite: plead facts regarding the defendant's state of mind without the benefit of discovery. However the standard is articulated, heightened pleading runs afoul of the preference for merits determination embodied in the federal procedural system. Such infringement is unwarranted, given the myriad of procedural alternatives available that preserve merits determination while balancing defendants' interests. The continuing and expanded use of heightened pleading by courts and Congress sounds an alarm. The trans-substance nature of the federal rules is in jeopardy. One of the chief departures of the federal rules from common law pleading is their embodiment of the principle that a simple, uniform system should control, regardless of the substantive claim asserted. This uniformity in pleading practice is undermined by judicially imposed heightened pleading requirements, as in civil rights cases. Congress further diluted trans-substantiveness with the PSLRA and Y2K Act. Uniformity, however, is desirable. Notice pleading is a clearly understood standard. Heightened pleading is not. While the bench and bar are at ease with notice pleading, heightened pleading introduces a litany of new struggles. It is mercurial in definition. It is applied inconsistently. Even when applied, more uncertainty as to the quantum of pleading proof necessarily ensues. The benefits of a uniform standard are lost. Confusion results. If unchecked, this erosion threatens to return us to the wonderfully slow, expensive, and unworkable common law pleading regime. By design, the uniformity of liberal notice pleading avoids this cumbersome system of specialized pleading. The transubstantivity of the federal rules is further desirable because it fosters greater social justice. Rule 8 and notice pleading allow for easy access to the federal courthouse. By reducing the barriers to entry, the creation of new legal theories of legal rights is easier and simpler than it was under the former code or common law pleading regimes. Creating such a procedural system that provides greater access to the courts certainly motivated the drafters of the rules. Heightened pleading, however, threatens this important purpose. By restricting entry, the use of heightened pleading jeopardizes the social justice advantage. Professor Clark was the principal draft person of the Federal Rules of Civil Procedure, as well as a noted authority on pleading. Behind his support for notice pleading was a fundamental jurisprudential commitment. Professor Clark believed that procedure, including pleading, should perform the office only of aiding in the enforcement of substantial legal relations. It is a means to an end, not an end in itself. The handmaid rather than the mistress of justice. Thus, he saw procedure not as valuable for its own sake, or as expressing a type of justice independent of the substantive law it enforced. To the extent possible, it was to be a perfect conduit through which the substantive law was enforceable. Contrast this view, Justice Frankfurter's statement that the history of liberty has largely been the history of observance for procedural safeguards. McNabb versus United States, 318 U.S. 332, 347, 1943. For a less lofty view of the independent importance of procedure, consider the view of a well-known congressman. I'll let you write the substance, and you let me write the procedure, and I'll screw you every time. One of the standard criticisms of the former systems of common law and code pleading was their penchant to decide cases on the basis of pleading technicalities rather than substantive merits. Without doubt, imposing a lot of pleading technicalities will cause some parties to lose cases that, in an ideal world, they should have won. But pleading technicalities also causes parties to lose cases that they should have lost, and at much less expense than the cost of full-blown pretrial and trial. Shouldn't we consider both the costs and the benefits of a stricter pleading regime? Or is a hallmark of modern procedural justice the enforcement of substantive rights as accurately as possible, regardless of cost? Evaluating the merits of notice pleading requires knowledge both of the other steps in the pretrial process and of their effectiveness. If a procedural system expects litigants to show up for trial with nothing but the pleadings to help them understand the case against them, it might require the pleadings to specify the legal and factual nature of the dispute in detail, at least if it cares at all about accurate decision-making at trial. On the other hand, if a procedural system contains inexpensive and accurate post-pleading devices for discovering the facts, identifying the law, and framing the issues for trial, it needs very little from the pleading process. As Professor Fairman mentions, the Federal Rules of Civil Procedure contain post-pleading devices to develop the facts, identify the law, and frame and narrow the issues for trial. Their system of discovery allows each side to investigate the factual basis for other parties' cases. Its systems of case management and summary judgment can frame and winnow the issues. How inexpensive and accurate these systems are, questions that chapters 3, 4, and 5 explore, is highly relevant to deciding whether a notice pleading approach is better than a more stringent alternative. Therefore, to some extent, you need to reserve judgment on our pleading system until you finish studying the pretrial process. Because notice pleading facilitates access to courts, Professor Fairman also links notice pleading to social justice. Open access to courts is a two-edged sword. Critics of the American system of civil justice sometimes claim that the United States is the most litigious society in history, and that the United States witnessed a litigation explosion in the later half of the 20th century. Although the truth of these claims is hotly debated, notice pleading does foster more litigation. That fact hardly makes notice pleading the root cause of American litigiousness. litigiousness. Among the developments that occurred contemporaneously with the rise in notice pleading were changes in substantive law that gave people more legal rights, as well as changes in social attitudes about suing major corporations and other institutions. But a pleading regime can encourage or discourage litigation, and thus can influence the level of litigiousness in a particular society. This influence is but one example of ways in which procedural rules invariably affect social behavior. Section B, the complaint. The pleading provisions in the Federal Rules of Civil Procedure are found in Rules 7 through 15. According to Rule 7A, the only pleadings allowed in a case are complaints, answers, and replies to the answer. Rule 7B distinguishes pleadings from motions, which are requests for a court order. According to Rule 3, a case is commenced by filing a complaint with the court. Rule 4 prescribes the ways in which a plaintiff must serve, in other words, provide a copy of the complaint to defendant. Rule 12 then requires the defendant either to file an answer to the complaint or to file a motion. A defendant can also do nothing, and the court will enter a default. This section examines the issues surrounding a complaint and its service. The next section explores motions and answers. The substantive and formal sufficiency of the complaint. Put yourself in the shoes of a lawyer representing a client who wants to file suit in federal court. You need to draft a complaint. Your complaint must pass muster under the pleading requirements of the Federal Rules of Civil Procedure. The principal rules that describe the minimal content for your complaint are Federal Rules 8A, 8D, 9, and 10. In addition, Rule 84 calls attention to the appendix of forms. These forms, which you can find at the end of the Federal Rules of Civil Procedure, illustrate the simplicity and brevity that these rules contemplate. The forms dealing specifically with the content of complaints are Forms 1, 2, and 7 through 21. At this point, you should read Rules 8A, 8D, 8E, 9, and 84, and Forms 7, 10, and 11. These rules and forms provide general guidance about the contents of a complaint, but they contain few specifics. They are not a cookbook that lists every legal and factual ingredient that every successful complaint must contain. Nor do they require magic language whose presence immunizes a complaint from attack, or whose absence automatically constitutes a fatal defect. Therefore, as a lawyer facing the task of drafting a complaint, you must use your judgment to determine whether your complaint compiles with the general admonitions of the pleading rules. In other words, you must interpret the federal rules and apply them to specific language that you have chosen for your complaint. Among the interpretive aids that you can use are prior cases that have involved the same federal rules. Conley versus Gibson, 355 U.S. 41, 1957. Mr. Justice Black delivered the opinion for a unanimous court. Once again, employees are here under the Railway Labor Act asking that their collective bargaining agent be compelled to represent them fairly. In a series of cases beginning with Steele versus Louisville in Nashville, this court has empathetically and repeatedly ruled that an exclusive bargaining agent under the Railway Labor Act is obligated to represent all employees in the bargaining unit fairly and without discrimination because of race, and has held that the courts have the power to protect employees against such invidious discrimination. This class suit was brought in a federal district court in Texas by members of the Brotherhood of Railway and Steamship Clerks, petitioners here on behalf of themselves and other employees similarly situated against the Brotherhood in its local union number 28 and certain officers of both. In summary, the complaint made the following allegations relevant to our decision. Petitioners were employees of the Texas and New Orleans Railroad at its Houston Freight House. Local 28 of the Brotherhood was the designated bargaining agent under the Railway Labor Act for the bargaining unit to which the petitioners belonged. A contract existed between the union and the railroad which gave the employees in the bargaining unit certain protection from discharge and loss of seniority. In May 1954, the railroad purported to abolish 45 jobs held by the petitioners or other who were either discharged or demoted. In truth, the 45 jobs were not abolished at all, but instead filled by whites as the Negroes were ousted, except for a few instances where Negroes were rehired to fill their old jobs but with loss of seniority. Despite repeated pleas by petitioners, the union did nothing to protect them against these discriminatory discharges and refused to give them protection comparable to that given white employees. The complaint then went on to allege that the union had failed in general to represent Negro employees equally and in good faith. It charged that such discrimination constituted a violation of the petitioner's right under the Railway Labor Act to fair representation from their bargaining agent. And it concluded by asking for relief in the nature of declaratory judgment, injunction, and damages. The respondents appeared and moved to dismiss the complaint because the district court lacked subject matter jurisdiction, because the plaintiffs failed to join the railroad as a party, and because the complaint failed to state the claim upon which relief could be granted. The district court granted the motion on the jurisdictional ground. The Court of Appeals affirmed. After holding that the district court had subject matter jurisdiction, and the railroad did not need to be joined, the Supreme Court addressed the union's argument that the complaint failed to state a claim. We hold that under the general principles laid down in the Steele cases, the complaint adequately set forth a claim upon which relief could be granted. In appraising the sufficiency of the complaint, we follow, of course, the accepted rule that a complaint should not be dismissed for failure to state the claim unless it appears beyond doubt that the plaintiff can prove no set of facts in support of his claim which would entitle him to relief. Here, the complaint alleged, in part, that petitioners were discharged wrongfully by the railroad and that the union, acting according to plan, refused to protect their jobs as it did of white employees or to help them with their grievances, all because they were Negroes. If these allegations are proven, there has been a manifest breach of the union's statutory duty to represent fairly and without hostile discrimination all of the employees in the bargaining unit. This court squarely held in Steele and subsequent cases that discrimination in representation because of race is prohibited by the Railway Labor Act. The respondents also argue that the complaint failed to set forth specific facts to support its general allegations of discrimination and that its dismissal is therefore proper. The decisive answer to this is that the federal rules of civil procedure do not require a claimant to set out in detail the facts upon which he bases his claim. To the contrary, all the rules require is a short and plain statement of the claim that will give the defendant fair notice of what the plaintiff's claim is and the grounds upon which it rests. The illustrative forms appended to the rules plainly demonstrate this. Such simplified notice pleading is made possible by the liberal opportunity for discovery and the other pretrial processes established by the rules to disclose more precisely the basis of both claim and defense, and to define more narrowly the disputed facts and issues. Following the simple guide of Rule 8F, that all pleadings shall be construed as to do substantial justice, we have no doubt that the petitioner's complaint adequately set forth a claim and gave the respondents fair notice of its basis. The federal rules reject the approach that pleading is a game of skill in which one misstep by counsel may be decisive to the outcome, and accept the principle that purpose of pleading is to facilitate a proper decision on the merits. The judgment is reversed and the cause is remanded to the district court for further proceedings not inconsistent with this opinion. Notes and questions. We are studying the sufficiency of the complaint, not the responses that a defendant can make to the complaint. Almost invariably, however, cases evaluating the sufficiency of a complaint arise when a defendant files a motion to dismiss under Rule 12b-6. We will have more to say about Rule 12b motions shortly. In brief, a Rule 12b motion seeks dismissal of the case due to defects in the case or the complaint. In Conley, the union claimed 3 such defects: a lack of subject matter jurisdiction, the failure to join the railroad, and the failure of the complaint to state a claim under Rule 12b-6. The first 2 grounds are unrelated to the issue we are studying. We will come back to them later. The final ground brings us to the present question: what must a complaint allege in order to be regarded as sufficient under federal rules? Rule 8A provides that a sufficient complaint must contain 3 elements: a short and plain statement of the grounds for the court's jurisdiction, a short and plain statement of the claim showing that the pleader is entitled to relief, and a demand for the relief sought. The union made 2 distinct arguments about why the complaint failed to meet the Rule 8A2 requirement. The first argument concerned the complaint's substantive sufficiency. The second concerned its formal sufficiency. A substantively sufficient complaint alleges behavior by the defendant that is a legal violation for which the plaintiff is afforded a remedy. A formally sufficient complaint meets the goal of notice pleading by providing enough facts to notify the defendant about the nature of the claim. Conley dealt with both the substantive and the formal sufficiency of the complaints. It stated a different test for each type of sufficiency. Make sure that you understand each test and how it differs from the other. Having established these tests, the Supreme Court then applied the test to the particular complaint before it. As a lawyer, this part of the case particularly interests you. Unless you are representing employees whose union is engaging in racially discriminatory practices, Conley does not apply directly or tell you exactly which facts to allege in your complaint. So you need to extrapolate from Conley by identifying the features in the Conley complaint that made it substantively and formally sufficient. Then you need to write your complaint to include the same features. To take one example, if you read the complaint in Conley, you discover that the plaintiff cited no cases. Yet, the Supreme Court found that the complaint was sufficient. That fact gives you useful information about whether your complaint must include cases and legal authorities. As Conley described the complaint and the law applicable to unions, There seemed to be no doubt that the complaint met the test for substantive sufficiency, nor did there seem to be any doubt that it met the test for formal sufficiency. So why did the union move to dismiss the case? One reason might have been that before Conley, the Supreme Court have never decided a case describing a plaintiff's pleading burden under the federal rules. In addition, defendants sometimes file motions to dismiss for tactical reasons. In responding to a motion to dismiss, a plaintiff will often describe the complaint's legal and factual contentions in more detail than the complaint did. Perhaps the union wanted to be sure that the plaintiffs were basing their case on steel rather than on a different body of law. By filing the motion to dismiss, the union forced the plaintiffs to lay out the legal theory on which they were relying. Thus, even if the union expected to lose, the motion to dismiss effectively got the plaintiffs to say more about their case than the complaint had. Is such a tactic a proper use of a motion to dismiss? You will want to think about this question again after you study Section E of this chapter, which concerns pleadings and motions filed for improper purposes. But the possibility of such a tactical use is itself an important object lesson. In an adversarial system, a party can almost always find a way to take a rule intended to serve one purpose and turn it towards a different purpose. The result in Conley seems consistent with the basic goal of notice pleading: to expect little of the complaint beyond notice of the rough outline of the plaintiff's case, and to leave to later pretrial processes a fuller legal and factual development of the case. The following two cases explore further the requirements for a sufficient complaint. The first case focuses principally on Conley's approach to formal sufficiency, and the second focuses principally on its approach to substantive sufficiency. Schwerkowitz versus Schwerma, 534 U.S. 506, 2002. Justice Thomas delivered the opinion for a unanimous court. This case presents the question whether a complaint in an employment discrimination lawsuit must contain specific facts establishing a case of discrimination under the framework set forth by this court in McDonnell Douglas Corp. Versus Green, 411 U.S. 792, 1973. We hold that an employment discrimination complaint need not include such facts, and instead must contain only a short and plain statement of the claim showing that the pleader is entitled to relief. Federal Rules of Civil Procedure 8A2. Petitioner Ákos Schwerkowitz is a native of Hungary, who at the time of his complaint was 53 years old. Schwerma was formed in 1989. It is a reinsurance company principally owned and controlled by a French parent corporation. At all times relevant hereto, Schwerma's chief executive officer has been Francois M. Chabel, a French national. On April 17, 1989, Mr. Schwerkowitz began his employment with Schwerma in the position of Senior Vice President and Chief Underwriting Officer. In all respects, Mr. Schwerkowitz performed his job in a satisfactory and exemplary manner. Despite plaintiff's stellar performance, in February 1995, Mr. Chabel demoted him from his CUO position to a marketing and services position and transferred the bulk of his underwriting responsibilities to another French national, Nicolas Papadopoulou, who was 32 years old at the time and 16 years younger than plaintiff. Mr. Chabel demoted Schwerkowitz on account of his national origin and his age. Mr. Papadopoulos was far less experienced and less qualified to be Schwarma's CEO than Mr. Schwerkowitz. Indeed, Mr. Papadopoulos had just 1 year of underwriting experience prior to being appointed CUO by Mr. Chevelle. By contrast, plaintiff had more than 26 years of broad-based experience in the insurance and reinsurance industry. At the time Mr. Papadopoulos assumed plaintiff's duties as CUO, Mr. Chevelle stated that he wanted to energize the underwriting department, clearly implying that plaintiff was too old for the job. Mr. Schwerkowitz was isolated by Mr. Chevelle following his demotion, excluded from business decisions and meetings, and denied the opportunity to reach his true potential at Schwarma. In the morning on Tuesday, April 29th, 1997, Mr. Chevelle and Schwarma's counsel met with Mr. Schwerkowitz and gave him two options: either resign his job with no severance package or be fired. Mr. Schwerkowitz refused to resign his employment. As a result, he was fired by Mr. Chevelle effective that very day. Schwarma had no valid basis to fire Mr. Schwerkowitz. Schwarma terminated Mr. Schwerkowitz's employment on account of his national origin and thereby violated his right to equal employment opportunity as protected by Title VII. Schwarma terminated Mr. Schwerkowitz's employment on account of his age and thereby violated his right to equal employment opportunity as protected by the Age Discrimination in Employment Act of 1967. The United States District Court for the Southern District of New York dismissed petitioner's complaint because it found that he had not adequately alleged circumstances that support an inference of discrimination. The United States Court of Appeals for the Second Circuit affirmed the dismissal. The Court of Appeals held that the petitioner had failed to meet his burden because his allegations were insufficient as a matter of law to raise an inference of discrimination. We granted certiorari to resolve a split among the courts of appeals concerning the proper pleading standard for employment discrimination cases, and now reverse. Applying circuit precedent, the Court of Appeals required petitioner to plead a case of discrimination in order to survive respondent's motion to dismiss. In the Court of Appeals' view, petitioner was thus required to allege in his complaint membership in a protected group, qualification for the job in question, an adverse employment action, and circumstances that support an inference of discrimination. McConnell Douglas, 411 U.S. at 802. McConnell Douglas, however, states an evidentiary standard, not a pleading requirement. In McConnell Douglas, this court made clear that the critical issue before us concerned the order and allocation of proof in a private non-class action challenging employment discrimination. In subsequent cases, this court has reiterated that McConnell-Douglas standard relates to the employee's burden of presenting evidence that raises an inference of discrimination. This court has never indicated that the requirements for establishing a prima facie case under McDonnell-Douglas also apply to the pleading standard that plaintiffs must satisfy in order to survive a motion to dismiss. For instance, we have rejected the argument that a Title VII complaint requires greater particularity because this would too narrowly constrict the role of the pleadings. Consequently, the ordinary rules for assessing the sufficiency of a complaint apply. See Shore v. Rhodes, 416 U.S. 232, 236, 1974. When a federal court reviews the sufficiency of a complaint, before the reception of any evidence either by affidavit or admissions, its task is necessarily a limited one. The issue is not whether a plaintiff will ultimately prevail, but whether the claimant is entitled to offer evidence to support its claims. Furthermore, imposing the Court of Appeals' heightened pleading standard in employment discrimination cases conflicts with the Federal Rules of Civil Procedure 8A2, which provides that a complaint must include only a short and plain statement of the claim showing that the pleader is entitled to relief. Such a statement must simply give the defendant fair notice of what the plaintiff's claim is and what the ground upon which it rests, Conley v. Gibson. This simplified notice pleading standard relies on liberal discovery rules and summary judgment motions to define disputed facts and issues and to dispose of unmeritorious claims. The provisions for discovery are so flexible, and the provisions for pretrial procedure and summary judgment so effective that attempted surprise in federal practice is aborted very easily. Synthetic issues detected, and the gravamen of the dispute brought frankly into the open for the inspection of the court. Rule 8A Simplified Pleading Standard applies to all civil actions with limited exceptions. Rule 9B, for example, provides for greater particularity in all averments of fraud or mistake. This court, however, has declined to extend such exceptions to other contexts. In Leatherman, we stated, the federal rules do address in Rule 9B the question of the need for greater particularity in pleading certain actions, but do not include among the enumerated actions any reference to complaints alleging municipal liability under 1983. Experieso uniest est exclusio alterius. Just as Rule 9b makes no mention of municipal liability, neither does it refer to employment discrimination. Thus, complaints in these cases and in most others must satisfy only the simple requirements of Rule 8a. Other provisions of the Federal Rules of Civil Procedure are inextricably linked to Rule 8a's Simplified Notice Pleading Standard. Rule 8E1 states that no technical forms of pleading or motions are required, and Rule 8F provides that all pleadings shall be so construed as to do substantial justice. Given the Federal Rules' simplified standard for pleading, the court may dismiss a complaint only if it is clear that no relief could be granted under any set of facts that could be proved consistent with the allegations. If a pleading fails to specify the allegations in a manner that provides sufficient notice, a defendant can move for a more definitive statement under Rule 12e before responding. Moreover, claims lacking merit may be dealt with through summary judgment under Rule 56. The liberal notice pleading of Rule 8a is the starting point of a simplified pleading system, which was adopted to focus litigation on the merits of a claim. See Conley, 355 U.S. at 48. The federal rules reject the approach that pleading is a game of skill in which one misstep by counsel may be decisive to the outcome, and accept the principle that the purpose of pleading is to facilitate a proper decision on the merits. Applying the relevant standard, petitioner's complaint easily satisfies the requirements of Rule 8a because it gives respondent fair notice of the basis for petitioner's claims. Petitioner alleged that he had been terminated on account of his national origin in violation of Title VII and on account of his age in violation of the ADEA. His complaint detailed the events leading to his termination, provided relevant dates, and included the ages and nationalities of at least some of the relative persons involved with his determination. These allegations give respondent fair notice of what petitioner's claims are and the grounds upon which they rest. In addition, They state claims upon which relief could be granted under Title VII and the ADEA. Rule 8A establishes a pleading standard without regard to whether a claim will succeed on the merits. Indeed, it may appear on the face of pleadings that a recovery is very remote and unlikely, but that is not the test. Schwer, 416 U.S. at 236. For the foregoing reasons, we hold that an employment discrimination plaintiff need not plead a prima facie case of discrimination, and that petitioner's complaint is sufficient to survive respondent's motion to dismiss. Accordingly, the judgment of the Court of Appeals is reversed, and the case is remanded for further proceedings consistent with this opinion. In Schwerkowitz, Schormer was not arguing that it was blameless, not arguing, in other words, that it should win on the merits. Instead, it was arguing that the plaintiff had made a procedural gaffe. The complaint failed to say the right things. Was Schormer arguing that the complaint was substantively inefficient, formally insufficient, or both? The vehicle that Schormer used to test the sufficiency of the complaint was a motion to dismiss. We will describe this motion in detail shortly. As its name indicates, a motion to dismiss seeks the dismissal of the case at the pleading stage. As long as this threat of dismissal exists, as it has since the days of common law and code pleading, lawyers must know how to plead well enough. So when is a pleading good enough? Consider the following model complaint. Based on the material that you have read so far, do you believe that this complaint will survive a motion to dismiss? In the United States District Court for the District of Massachusetts, Virginia Rose, plaintiff versus David Young, defendant. Complaint. 1. Plaintiff Virginia Rose is a citizen of the state of Massachusetts. 2. Defendant David Young is a citizen of the state of Rhode Island. 3. The amount in controversy in this case exceeds $75,000. 4. On August 14, 2004, on Boylston Street in Boston, Massachusetts, defendant drove a motor vehicle against the plaintiff while she was crossing the street. 5. As a result, the plaintiff was knocked down, was physically injured in her person, lost wages, suffered physical and mental pain, and was incurred medical expenses. 6. Wherefore, plaintiff demands judgment against defendant for at least $2,000, plus costs and other such relief as the court deems just and proper. Plaintiff demands a jury trial. Respectfully submitted, blah, 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 blah. Schwerkowitz refers to the burdens that a plaintiff must shoulder both in the allegations in the complaint and in the evidence that a plaintiff must present at trial. The term burden is thus used in multiple senses. With respect to pleading, it has two meanings. First, one of the parties must raise an issue in order for it to be included in the case. That party is said to have the burden of pleading that issue. For instance, if the substantive law treats the plaintiff's contributory negligence as barring recovery, even if the defendant was negligent, pleading rules may either require the defendant to plead the plaintiff's contributory negligence as a defense, thus putting the pleading burden on the defendant, or require the plaintiff to plead that he or she was not contributory negligent, putting the burden on the plaintiff. Second, the term burden refers to how much a party must include in a pleading. In a federal court and in state systems that adopt federal-style notice pleading, the plaintiff's burden is fairly modest. As we have seen, a plaintiff does not need to allege every fact or include every legal authority on which the plaintiff will rely in order to win. Distinct from these two pleading burdens are evidentiary burdens that are often referred to under the label burden of proof. That term can be imprecise, as it may refer either to a burden of production or to a burden of persuasion. The law of evidence allocates to one party or the other the obligation to introduce enough evidence to create a factual dispute that a fact finder can decide. The party who must introduce evidence on a disputed point is said to have the burden of production. Usually, plaintiffs have that burden as to each element of each of their claims. On affirmative defenses, however, defendants usually have the burden of production. Sometimes, a party with the initial burden presents such strong evidence that, absent countervailing evidence, a rational fact finder could decide only its way, thus shifting the burden of production to show a factual dispute to the other side. A decision about which party bears the burden of producing evidence is made by the judge, who leaves a matter to the fact finder if the burden is met, but who takes it away from the fact finder if the burden is not. Sometimes you will see the term prima facie case. A prima facie case refers to the bundle of elements that a plaintiff must prove in order to prevail on a particular claim. For instance, in most states, the prima facie case for the typical non-intentional tort is duty, negligence, causation, and damage. When the plaintiff meets his or her burden to produce evidence on each of these elements, then the plaintiff has made a prima facie case. A plaintiff who cannot make a prima facie case loses. But the converse is not necessarily true. Making a prima facie case does not mean that the plaintiff wins. Rather, the defendant can still win either by proving a defense or by introducing evidence that discredits or disputes the plaintiff's evidence. When an opposing party introduces evidence that discredits or disputes the other side's evidence, the burden of persuasion becomes relevant. A burden of persuasion involves the fact finder's weighting of the evidence that the parties produce. The persuasion burden with which you may be most familiar is the criminal one. The prosecution must prove each element of a crime beyond a reasonable doubt. The usual burden of persuasion in a civil case is fair preponderance of the evidence, a less exacting standard that requires a party with the burden to persuade the fact finder that the evidence more likely than not supports the view. Typically, the plaintiff bears the burden of persuasion for each element of a claim. The defendant bears the burden of persuasion for each element of a defense. Thus, in order for a plaintiff to win on a particular claim, the fact finder must be persuaded to slightly more than 50% degree of confidence that the plaintiff's evidence on each element of the claim is credible. On the other hand, if the fact finder thinks the evidence is a tie, or that the defendant's view of the evidence is more persuasive, the plaintiff loses. The converse propositions hold for matters on which the defendant has the persuasion burden. In jury cases, burdens of persuasion involve not decisions by the court, but instructions by the judge to the jury about what standard should apply to weighting the evidence. Your courses in substantive law will explore the prima facie elements of various claims and defenses. A course in evidence will explore burdens of proof in more detail. Schwerkowitz is an illustration of how the Conley standard has traditionally been applied by the courts. In the next case, the Supreme Court may or may not have changed that standard. We will resume tomorrow on page 45, Bell Atlantic Corp. Versus Twombly. When I snap my fingers, you will wake up and you will be closer to understanding the rules of civil procedure. In 5, 4, 3,